Okay. All right. Thank you. And welcome to the Nevada Legal Services Habitability class. My name is Dawn Jensen. I'm one of the attorneys at Nevada Legal Services. And also with me today is Zoraida Cruz. She's one of our housing counselors. Say hello, Zoraida.
Hi, everyone.
Okay. So before I begin with the presentation, I'd just like to give people a little understanding about our Tenants' Rights Center at Nevada Legal Services. Our Tenants' Rights Center is a special little department at NLS where we assist low-income individuals specifically with landlord-tenant issues. The advocates who work in that department usually give advice and self-help instruction. So if you have any issues going on with your landlord and you have questions, whether they be habitability questions or eviction questions, or any kind of landlord-tenant question, please feel free to reach out to our Tenants' Rights Center. You can complete an intake to get TRC services either online, or you can call us by phone, or you can stop in our office. Our telephone number is 702-386-0404, and you want to request the Tenants' Rights Center. Or you can come into our office at 530 South 6th Street on the corner of 6th and Bonneville. Okay, so that's a little bit about our Tenants' Rights Center. I just like to make people aware of that. Also, before I begin the instruction, I want to make sure those of you who signed up for this class today should have received a packet in your email, and that packet includes the habitability information, and it also includes sample letters that we're going to talk about what those sample letters are used for and when to use which ones, but you have those in your packet. So feel free to look through those materials either during the presentation or afterwards. They're yours to keep. And if you did not get that packet, please feel free to reach out to our office by phone. Just talk to the receptionist, let them know that you attended our class and that you didn't receive the materials, and we'll be happy to email you a packet, okay? Okay, with that being said, I'm going to go ahead and begin the instruction. So again, today's class is about habitability. So what does habitability mean? There is a legal definition to that word. It's NRS 118A-290. It's rather long, but basically what habitability means under the law is a unit is habitable when it is capable of allowing an average person to use and enjoy the dwelling and live free of defects that affect health or safety. And in the legal definition, it actually kind of goes through and enumerates certain things that do constitute a habitability problem. So for example, if you have an issue with, let's say, your plumbing, which is listed here as letter B, that is going to be a habitability problem. If you have something wrong with your floors or your walls or other services such as AC, that is going to constitute a habitability problem. Some things do not meet that definition, and we'll talk about that in a minute, but this definition here includes the things that are habitability problems. How do I move forward? Hold on one second. There we go. When you have a problem that isn't a habitability issue, there's another law that pertains to that. So what it really boils down to, the difficult part in the law when you have a habitability problem is knowing which procedure and which rights you have depending on which kind of problem you have. And this class will break down the different types of problems and how you go about handling each one, because it's just slightly bit different. So I'm going to go through these one by one, but we're going to begin by talking about 118A-355, which talks about what to do when you have something that actually constitutes a habitability problem. That law tells you what you can do when you have a habitability problem. 118A-350 talks about what's called lease violation problems and what you can do legally when you have a lease violation problem. 360 talks about lease and habitability violations. It's a special little section of the law, and we'll talk about that shortly. And 380 is a section of the law that specifically tells you what to do when you have something that constitutes an essential service problem. And that's a little bit different from habitability, and we'll go through that in just a minute. Okay. So what I like to kind of do is give this little summary before we get into each one of those sections. Because before you jump forward in any kind of legal process, there's things you kind of want to ask yourself before you get ahead of yourself. So step one, before you start moving forward with your legal issue and your legal rights, you want to ask yourself, what is the problem that you're having in your unit? Literally, what is it that's broken? And does that thing that's broken constitute a habitability problem? Does it constitute a lease violation problem? Or does it constitute an essential service problem? And when you can decide that, you will proceed in the appropriate legal way, okay? And by the end of this class, hopefully you'll know the difference between all three of those. Then you also want to make sure you ask yourself before you get started, who is responsible for that item breaking, or who's responsible for it not working? Under the law, if the tenant or the tenant's guest caused the problem, the landlord is not responsible for fixing it. So if you broke it, you buy it, kind of a thing, right? If your dishwasher is not working because you broke the dishwasher, you got to fix the dishwasher. But if the dishwasher just broke all on its own, which sometimes they do, then you can proceed legally, okay? Also, don't forget, just because you didn't do it, your guest or your dog or your children, the same thing goes, okay? Also, step three, before you jump into the legal process, ask yourself, once you start this, if your landlord makes a reasonable attempt to fix the problem, you cannot proceed anymore. So if you start this process and the landlord does do what they're supposed to do, which is come over and fix it, then you don't need to go any further. Your legal issue is resolved. But if your landlord does not fix the problem, then step four is you want to think about, before you get started, what do you want to do? If your AC is not working and you notify your landlord and it doesn't get fixed, what do you want to get out of this in the end? What do you want to do? What will make you happy? Do you want to withhold your rent? Do you want to terminate your lease? Do you want to abate the unit, or do you want to sue your landlord for damages? Because these are all going to be choices that you will have to make. Okay, so as I said, we're going to talk about each one of those three categories, and we're going to begin with whether or not a problem actually constitutes a habitability problem. Again, I show you the definition under the law. It specifically enumerates things that do constitute habitability problems, but you could also argue as a tenant, anything that affects health or safety can be a habitability problem. So if your thing that's broken isn't specifically mentioned here, if you can argue that it's a health or safety issue, it may be a habitability problem. For example, the sewer. If you have sewage backing up. It doesn't exactly say that in here, but that could probably constitute a habitability problem because it does affect health and safety. Okay, so if you determined that the thing that's broken is a habitability problem, then what can you do? What the law says that you can do is that you send a written notice to the landlord specifying what's wrong. You must give the landlord 14 days after receipt of that notice to make best efforts to repair. As I had told you earlier, if the landlord starts repairing it, you may not proceed. Your issue has been resolved. But if you give the notice and the landlord does not make repairs and they have not made a reasonable effort to do anything within those 14 days, then the tenant has to decide whether they want to terminate their lease, withhold rent, or sue for damages. And those are your legal remedies. Most tenants will choose to withhold their rent. It's the most practical thing to do, and it usually gets the attention of your landlord rather quickly when you withhold your rent. But there's a few things you want to know about withholding rent before you do it. If your landlord fails to make best efforts to fix the problem after you've given that 14-day notice, you legally may withhold your rent, but you cannot withhold rent if you are already delinquent in rent. You must be current on your rent when you start withholding. If you start withholding your rent and you receive a 7-day pay rent or quit notice soon thereafter, which very well may happen, you are going to want to file a tenant's affidavit with the court, which is your response, and you're going to want to deposit that rent money with the court at the same time that you file your answer, okay? Which means when you withhold your rent, you have to actually withhold it, right? It doesn't mean you get to spend it. The law doesn't say that you don't have to pay your rent. The law says that you may withhold your rent, and you can keep holding on to it until this matter is resolved with the court, okay? But don't spend it. Make sure you actually have that money, because if the landlord takes action against you, you will have to deposit it with the court to show proof that you have it still, okay? So what if the problem that you're having with your unit isn't really a habitability problem? What if it doesn't fall within that definition and it doesn't seem to fit into that list of things that we talked about earlier? Then there's a very good chance that the thing that's broken, the thing that's wrong with your unit, may constitute what's called a lease violation. If your problem does not meet the definition of habitability, but it is a lease violation, then you follow the process that's enumerated in 118A 350. It's very difficult for me to tell people what is and what isn't a lease violation. There's lots of things that could constitute a lease violation, but some very common examples of this would be appliances, such as the microwave, or maybe your dishwasher, or maybe the washer and dryer in your unit. Those things might not constitute a habitability problem. If you look at the definition, you can see that they may not really fall within that definition, but they are a lease violation problem. So if you're living in your unit and your dishwasher goes out, your landlord still does need to fix it. It's just that the process is a tiny bit different. You still need to file a written notice to your landlord, or you still need to send a written notice to your landlord. You still provide 14 days for the landlord to make best efforts to repair. If the landlord repairs, problem solved. If the landlord does not make repairs, then you only have two choices. You may terminate your lease, or you can sue for damages. You cannot withhold rent when you have a lease violation problem. That's the primary difference. When you have something that's a habitability problem that's broken, you have the right to withhold your rent. When you have something that doesn't meet that definition, but it's a lease violation problem, you can terminate your lease, you can sue for damages, you may not withhold your rent. As I mentioned earlier, there's one other section of the law that applies to both problems, and it's called repair and deduct. 118A 360 is a section of the law that provides you an alternative remedy. So this section of the law doesn't really care whether you have a habitability problem or a lease violation problem. What allows you is a different remedy, which is to repair and deduct the problem. You still need to provide a 14-day notice. You still need to give your landlord 14 days to make best efforts to repair. But if the landlord fails to do so and 14 days lapse, then you can repair and deduct. So there's a few little exceptions to this. The repairs may not cost more than 1 month's rent, and you can only repair and deduct a total of 1 month's rent in a 1-year period. That's not too common in my experience, but however, sometimes repairs could cost more than 1 month's rent. So let me give you an example. So let's say you have the broken dishwasher again, okay? It's not really a habitability problem, probably more of a lease violation problem. You do want to give a 14-day notice to your landlord, but let's say the landlord just completely blows you off and does nothing. 14 days come and go, and the landlord does not even make best efforts to repair. You could opt to repair and deduct the dishwasher yourself. So maybe it would cost, let's say your rent is $800 a month, and maybe you can get a new dishwasher for $400. You can go ahead and put a whole new dishwasher in, because the cost of the dishwasher, or maybe just to repair the old one, is $400. The cost of repairing that item is less than 1 month's rent. So it's okay, you can do that. We do caution you, you might want to check your lease sometimes. Sometimes there's certain things in your lease that your landlord will specify who they want to make repairs. For example, some people who have swimming pools, if you rent a place with a swimming pool, if something goes wrong with the swimming pool, your lease may specify who needs to complete repairs. You need to follow what your lease says. You don't want to violate your lease by using a different repair company, but you still can go ahead if you have such a problem and get the unit repaired. Hold on one second.
I want walker. I want walker, Mommy.
Okay. Lastly, is the problem an essential service problem?
Mommy,
Z, can you take over from here?
I want walker.
Hi.
I have to control the PowerPoint for you.
Oh, okay. Essential services.
Control over it.
I'm sorry?
Can you see it?
Yes.
Okay, go ahead.
Essential services, NRS 118A.380 states if you lack an essential service as a result of your landlord's willful or negligent act, you can use 118A.380. Essential services include heating, air conditioning, hot and cold, running water, electricity, gas, working door, lock, or another essential item of service. AC is only an essential service if required in your lease or the service worked when you moved in. In Southern Nevada, most dwellings have AC, but make sure the AC works before moving in. You want me to continue?
Yeah.
Essential services, NRS 118A.380, must be the result of the landlord's willful or negligent actions or inactions. If the essential service problem is not the result or willful or negligent actions of the landlord, then you may proceed with a 14-day letter described earlier. If you proceed under NRS 118A.380, you may not also use the remedies of NRS 118A.350 and NRS 118A.360. You can only proceed under one law.
Thank you. Yeah, I needed a mommy break. Sorry. So, right. I just like to go through this one a little bit. What Ms. Cruz said was very important. One of the things that I like to highlight that's different about essential service problems is you have to lack the essential service due to your landlord's willful or negligent act. I know that's very confusing to people sometimes, and sometimes it's very hard for a tenant to know whether they lack the essential service due to their landlord's willful behavior or due to negligence. It's hard to know. Sometimes things just break and a tenant doesn't know why it's not working, right? That's usually the scenario. My advice to that and what I usually tell people is if you're lacking as you can see, there's certain things that constitute essential service, as Ms. Cruz just described to you. If you're lacking one of those things, as long as you can keep a straight face in front of a judge, you should proceed under the essential service statute. The reason for that is when you have an essential service problem, you kind of follow the same process. You still have to provide a written notice to the landlord, but you only have to give 48 hours. So you give your landlord the written notice, the landlord has 48 hours to make repairs. That 48 hours does not include weekends and holidays. Mind you, just keep that in mind. But still, it's a much shorter time period for the landlord to have to fix something, or at least make best efforts to fix them. So going back to this, sometimes people don't know exactly why, let's say their air conditioning isn't working and it's July and it's 115. They don't know what's wrong with the AC. All they know is that they don't have it. If it turned out that your landlord had somebody come over and fix it and they gave crappy repairs and they used somebody who wasn't qualified, arguably they negligently took care of your air conditioner and now you have a broken air conditioner, and that would be a negligent act by your landlord causing you to not have an essential service, which would be AC in the summer. But sometimes, like I said, it's very hard for a tenant to know that. So if you have something wrong with an essential service, you should proceed under this statute as long as, like I said, you can keep a straight face with a judge as to why you're only giving a 48-hour notice, okay? Let me get back to this. So again, when you do have an essential service problem, same kind of process, you still have to give that notice to your landlord, but this time the landlord only gets 48 hours to make repairs. The other slight difference with essential service problem is if the landlord fails to make the repairs, a tenant has several remedies. They have several solutions to the problem available to them. They can repair and deduct, which might not be feasible because it might be a larger problem and it might be kind of expensive. So maybe that might not be the best option, but legally you can repair and deduct if that's feasible. You can sue your landlord for damages. You have the legal right to withhold your rent, or you can obtain comparable substitute housing while the service is not working. And while you are in that substitute housing, you don't owe rent for the unit that you have. And if the substitute housing costs you more on a prorated daily basis, then you can recover that difference from your landlord. Here's what I like to say about essential services. This is especially a problem here in Vegas this time of year. A lot of people have air conditioning, and in this town, if you live in the north, this might be different because you don't get quite, most of the time, they don't get as extreme of conditions or as extreme of temperatures as we do in Las Vegas. So maybe that might not constitute an essential service problem in the north sometimes. But in Vegas, in the summer, when AC is out, most judges will agree that you have an essential service problem, and they will agree that you need to handle it in this manner. So when you give the landlord the 48-hour notice, there's a good chance that the landlord's not going to get the AC fixed in 48 hours. So you can withhold your rent if that's an option that appeals to you. Again, you have to be current on your rent when you withhold, and you make sure you don't spend it. Hang on to that rent money, because if there's a dispute later on in court, you're going to need to prove that you still have it, right? Or a lot of people will often, especially with the AC, opt to go stay someplace else. And you do have the right to do that, but just remember, please keep all your receipts. Don't go stay at the Bellagio. Try to find something that's reasonable because you're only going to be entitled to recover the prorated difference anyways, right? So you don't want to go stay someplace that's super expensive because you might have problems trying to recover that full cost. And do always make sure you keep receipts and proof of everything. And don't forget, you still got to send that 48-hour notice first, and you got to give the landlord that full 48-hour period. And it doesn't include weekends. If you give it on a Friday, then you have to wait till like Tuesday to do anything, okay? If the landlord completes or repairs the essential service problem, you do need to go ahead. If you started withholding your rent, you do need to go ahead and give that rent to your landlord. And you know, there's always a level of reasonableness to some of these problems. If you have, as I said to you, you want to be able to keep a straight face. If you have to go into court and argue about these things in front of a judge, you want the judge to feel that you did the right thing, right? Because these things can go a lot of different directions. Arguably, a landlord cannot get the AC fixed a lot of times in 48 hours in Las Vegas in the summer. They might have trouble getting a contractor out there, but if they're making best efforts, then they're probably doing what they're supposed to do. But if you feel that they're not and you start withholding your rent, then just make sure you follow the law. And if you end up in court and you explain it to a judge, they'll understand what you're doing and you know what was going on. Last word about notice. As we've mentioned several times throughout this presentation, when it comes to providing notice, we strongly advise that you always send the notice. Under any condition that we've discussed, every one of them requires providing written notice to your landlord. Don't skip that step, okay? Whether it be the 14-day notice or the 48-hour notice, some sort of notice needs to be given to your landlord before you start doing stuff. You don't get to just not pay your rent on the first. You have to give that notice first under all situations, under all the examples that we've provided, okay? Also, I like to let people know, because they ask this question a lot, the law does not require that the notice be mailed. It doesn't require that it be certified. I recommend, I would highly recommend that you mail the notice and that you mail it certified, because that's solid proof that it was provided to the landlord. But if you want to, you can drop that notice off in person. If you can go into the office and give them a 14-day notice, there's nothing wrong with that. That's perfectly legal, and it's faster. You can give them the notice faster, but I would still back it up with mailing a certified copy, just so you have proof that they were provided that notice. Make sure you keep a copy of everything all the time. If you write out the 14-day letter, the 14-day notice, don't stick it in the mail and not keep a copy for yourself. Make sure you keep a copy of everything for yourself. And make sure you wait the full 14 days or 48 hours and give that landlord the period that they are entitled to. Don't start withholding your rent on day 12. You can't start withholding until 14 days have lapsed, and it's 14 consecutive days, okay? 48 hours does not include weekends and holidays, but the 14 days does. It's 14 days, 1 through 14, no matter what days of the week it is. But make sure you wait that whole time period. If you end up in court on these things later on, and there's a very good chance that you will, because if you take some of this action against the landlord, you may get an eviction notice. And if you get an eviction notice, you'll have to file an answer and you'll have to go into a hearing. And when you get to that hearing, you want to be able to explain to the judge everything that you did, and you want to be able to have the proof to show him why you did what you did, okay? Let me just see if there's any questions. If you have, where's the chat option? Oh, here we go. I'm not seeing any. Oh, okay. There's one question here from Mary. Does email count as notice? That's a good question. My personal opinion to this is it's going to depend on the judge. But I think under the actual legal definition, it could constitute notice. I think these days it pretty much is. I think what's most important is if you're going to email, I would still kind of back it up with an actual 14-day notice. The packet that we emailed out to everyone has a sample letter. However, a lot of times people do this, and in hindsight, they did follow the process by emailing their landlord. And it didn't exactly constitute an official 14-day letter, but when you look at the email, it kind of constitutes a 14-day letter because it says all the things that it should say. So if a person was to email their landlord to put them on notice, I would hope that that email would include the same things that the 14-day letter should include, which is, this is the problem, this is when it started, and it should kind of say in there, if you don't fix this problem, I'm going to withhold my rent, or I'm basically gonna invoke my legal rights. I'm gonna terminate my lease, or I'm gonna do what my legal rights allow me to do if this is not fixed within 14 days. And I would really like if the email include a 14-day reference so that the landlord knows they're getting a 14-day notice, a 14-day letter, and it kind of complies with the law. Does that make sense? Did that answer your question, or do you have more on that? Okay, so Mary also asks, if you don't have an address to the landlord, then what? We actually encounter this problem a lot. I would have to probably do, if you continue to have a problem with this, you should probably come to the Tenants' Rights Center. But how do you provide your rent? If you can answer that question for me. Okay, I'm not seeing. Okay, well, I'm going to assume that, let's say you pay your rent on an online portal, which some people will do, and they do have a difficult time finding an address for their landlord. This is kind of hard to say, but if you, sometimes, first of all, you can go to the assessor's website, put in an address and find out who the owner of the property is, and you can find an address for the owner of the property that you live in on those recorded documents, the property documents. So sometimes you have to get a little bit clever, but this can be an issue. And if you also, here's the other thing, then especially an email or a text message, whatever way you have of documenting this notice to the landlord is what you'll have to do. And that's kind of what I meant by when you go into court, as long as you can hold a straight face. I've heard all kinds of different situations in this town, and I've been amazed at how difficult of a time some tenants have in getting in touch with their landlord. But there's usually you have some way of paying your rent. Now, some people pay their rent online. And they really don't have a whole lot of personal information on their landlord. But whatever you can do to document this notice is what you should do. And when you go into court, like I said, even a text message might be the best option for you. And as long as that text message lays out the information that a 14-day notice should say, I think that if you explain it to a judge and then you let the judge know that you don't have any address information for the landlord, the judge will be receptive to that and the judge will listen to that. Also, according to certain laws, your landlord is required to provide an address, but that doesn't do you any good if they haven't provided you one. Just because the law makes them do it, if they don't do it, that doesn't really help you in your time of need. So whatever way you can document putting them on notice is what you should do. Any other questions? Let me just see. Let me just check the. Okay. We have one more. Okay, so the other question that came in is my oven doesn't have a front part of the door, but it works. Is that legal? Well, here's what I would say. It's hard for me to know too sometimes, but if whatever's wrong with your oven is causing it to run the risk of being hot to the touch, so like let's say you had somebody's child over at your unit and they touched the oven door with the way that it's existing as of right now, that could be a health and safety concern. So I would argue that especially if it makes it a little more dangerous due to the heat, I would say that is a habitability problem. It would also probably, if it didn't constitute a habitability problem, in other words, if there wasn't a health and safety issue there, but it was just broken and it looked ugly, it would probably constitute a lease violation problem because in your lease, it entitled you to an oven that works, that looks the way an oven's supposed to look. So if the oven's broken in some fashion, you would probably have at a minimum a lease violation problem. But if it's hot to the touch because of the way the door is, I'd say that's a habitability problem. Either way, you're going to proceed with the 14-day letter. It's just your rights, if they don't fix it, are a little bit different, whether it's habitability or lease violation. Any other questions? Okay, and again, you all should have received, I think we had one or two people who joined a little bit late, so all of you should have received that packet that has the samples of a lease, it has a sample habitability letter, it has a sample lease violation, and it has a sample essential service letter in that packet. And then it also has some of the information that we've provided here today. So in case you forget it all, because I know it's a lot, it's in there for you. And if you haven't gotten that packet, please let us know. We got another question. If the apartment across from you or beneath you, is there a work time for it start to, okay, for work to start and end? Is it correct to begin at 6:45 a.m. and end at 8 p.m.? I don't think that's really a habitability problem. Sometimes there are city ordinances and you could maybe call code enforcement or some city ordinance hotline to find out if there's any kind of ordinance in your area that about noise. I know sometimes, what do you call it? HOA communities. If you rent a place in an HOA community, the HOA will have rules about when construction can begin in the morning and when it can end. Sometimes it is kind of early. 6:45 seems really early to me, but sometimes they can start at 7, 8 a.m. But as far as that being a habitability problem, no, that's not going to constitute a habitability problem. It really depends upon where you, and there's a good possibility, depending on where you live, that there is no rule about that as to how early construction work can begin. And of course, it probably also depends on who's doing it, whether it's a private company or the city or who's doing it. But it's certainly annoying. I wouldn't want to be woke up at 6:45 a.m. But not a habitability problem, sorry. Any other questions? I think I got one more. Yep. Oh, they're rehabbing the apartments. Yeah, if it's an apartment complex and you live in another apartment complex, there's probably, unless, like I said, it violates a city ordinance, and that I'm not so sure about. It probably doesn't, because you see that they do construction in the middle of the night in some places too. So yeah, they're probably allowed to do that. Anything else? You're welcome. Okay. Thank you for being so patient. Sorry that my child makes noise in the background, but I hope you enjoyed the presentation. I hope you enjoyed our class. And as I said, please feel free to reach out to the Tenants' Rights Center at Nevada Legal Services anytime that you need help with a landlord-tenant issue. We're here for you. Also, please check out our YouTube page. We have lots of other videos on lots of other topics, not just landlord-tenant, but other legal issues as well that may be of interest to you. Thank you for attending our class, and good luck out there. Thank you.